on record. Good afternoon, counsel.
Good afternoon, Judge.
All right, I take it everyone can see and hear me okay. Before I call the case, I see Kay Biggs in the online waiting room. Is he associated with either one of you gentlemen?
He is, Your Honor. He's just filed a notice of appearance on behalf of the plaintiff in this case. He's going to be joining me as co-counsel.
Is that Mr. Kenneth Biggs?
Yes, Your Honor.
Okay, we'll bring him in. All right, counsel, if we are ready to proceed, this is cause number 18-123, Heitzman versus Bohannon. And I believe, Mr. Hagan, we're here on your motion to strike the counter affidavit. Is that correct?
That's correct, Judge. And we're here and ready on behalf of the plaintiff.
All right. And Mr. Fletcher, are you ready on behalf of Mr. Bohannon?
I am, Your Honor.
All right, go ahead, Mr. Hagan. I'll tell you that I have read the motion to strike. I have also read the motion for leave filed by Mr. Fletcher today, or I don't know if it was filed today. It was received by the court today. So I've reviewed both of those. So go ahead, Mr. Hagan.
Your Honor, basically, when I filed my motion, we had two arguments here. The first and primary argument is that the simple fact is that this the counter affidavit in question filed by the defendant was untimely filed. So Your Honor is aware the rules governing affidavits in this case, they are as they were when the case was filed, which was prior to the law change that happened back in 2019. So back in the before time, so to speak, when we had to deal with this corona epidemic and all that, the rules were that you had to file a counter affidavit within 30 days of being served with the actual affidavit on costs or services. That did not happen in this case. The counter affidavit was not filed for over 200 days after our initial affidavit was served. Judge, at no point in time did the defendant file a motion for leave prior to filing their affidavit, their counter affidavit. And at no point in time, really, before or since, have they indicated that there's any kind of good cause or cause at all for needing leave to file that counter affidavit. There doesn't seem to be a reason why they couldn't have filed that counter affidavit timely, and I don't believe one has been proffered so far. So that's our primary argument. Additionally, Your Honor, that the counter affidavit itself is it has to comply, just like under the rules, it has to comply with 702 and those requirements. And Judge, if you look at this affidavit, it is not. It's vague and it provides to give adequate notice, reasonable notice to us what the basis for their contentions are as to why the medical expenses in this case were unreasonable. And, you know, we can go into that more in depth, but I think the motion pretty well sums it up. And our primary argument, Judge, I think doesn't even, you know, once you rule on that, I don't think you even reached our secondary argument. So that's our position. As far as the motion for leave goes, Judge, I think technically that's a separate motion. It would need to be set for a hearing 3 days at minimum 3 days after it was filed. And so I don't know that that's properly before the court this morning.
No, I don't believe it is either. I just want to let you know that I have reviewed it. I reviewed it in anticipation that it may be brought up in today's hearing. So I wanted to go ahead and get a little ahead of the game. All right, Mr. Fletcher, do you want to respond to Mr. Hagan?
Judge, in all candor, Mr. Hagan is right. This was an affidavit of medical records that was provided by the plaintiff to my office. Judge, it was a long time ago. It was 12 to 14 months ago when I responded. As best I can recall, as an officer of the court, I had a paralegal at that time that didn't do something, and That's not an excuse. But in any event, once I found the expert, I filed my controverting affidavit. I would simply say that falls squarely on my shoulders, Your Honor, for not doing that properly. I concede that it wasn't filed within 30 days per the old law, and it wasn't filed timely per the new law. The only thing I'm asking, Judge, is that under 18001, it specifically provides the court with the option, subject to leave of court, at any time before evidence commences, to grant a motion for leave to file a controverting affidavit that the plaintiffs have had in their possession for some 14 months. And that's all I'm asking, Judge.
Mr. Hagan.
Your Honor, I don't know if you really want to take up the motion for leave, but all I would say in regards to it is they had plenty of time under the old rules, 30 days to file their counter affidavit initially. They had plenty of time to file a motion for leave prior to filing their counter affidavit. They had over 200 days to file a motion for leave and ask the court to file their counter affidavit untimely. They had plenty of time since actually I filed a prior version of this motion back in the beginning of December. They've had over a month where they could have filed a motion for leave. It's only been today that they finally did it. And at no point, again, Your Honor, have they stated any cause relevant to this suit that would, show some justification as to why they're entitled to relief from the deadlines set by the rules that the plaintiffs certainly have to follow. And Your Honor, I think absent a showing that it's in your discretion to grant leave or not. And I think absent some kind of showing that they're entitled to leave, you should not grant it. You should make them play by the same rules that plaintiffs across the state of Texas have had to play by for the past several decades. So that's what I would argue were the motion for leave properly before you, Judge. But again, it's my position that it's not.
All right, thank you, Mr. Hagan. Mr. Hagan, a couple of questions. In reviewing the clerk's record, it appears to me that there were some additional notices of service of necessity and reasonableness cost affidavits filed in April of 20. Is that correct?
Judge, that was when our notice was filed with the court, but the affidavits themselves were all filed at the same time back in, if I can look at the date real quick, Your Honor, I'm sorry, I blanked on it.
Okay.
March 2019 is when the counter affidavit or the affidavits were filed on the defendant. We filed, I'm sorry, I should be more clear. The affidavits were served on the defendant back in March 2019. That's the relevant date in time that we have to look at. When we file notice with the court that service took place is sort of that's not really relevant to their deadlines as to when they have to file counter affidavits. That's just, we have to get those on file with the court to comply with the rules and to both with regard to 18001 affidavits specifically and business record type affidavits in general. We have to get those on file with the court within 10 days of trial, 30 days of trial, respectively. So that's what that was about. It doesn't really impact the defendant's duty and to file counter affidavits timely.
And there was no additional new affidavits served
No,
contemporaneous with your notice?
I don't believe so, Judge.
I would concur.
Okay. All right. Thank you, Mr. Fletcher. All right. I guess based on the argument of counsel, court at this time is going to grant the plaintiff's motion to strike the counter affidavit of Dr. Lepak, I believe, as it may be pronounced. Court's going to find that there's not been a showing of just cause for the late filing of the counter affidavit in this case. And I know that may frustrate things as we are on the eve of the bench trial, but I believe that would be the just administration of the rules.
Thank you, Judge.
Thank you, Judge.
And Mr. Hagan, do you want to file an order reflecting the ruling of the court?
I will shortly, Your Honor.
Okay. Is there anything else that we need to address today?
Nothing from the plaintiff, Your Honor.
Nothing from the defendant, Your Honor.
All right. Thank you, gentlemen. I appreciate you joining me today and appreciate you appearing on Zoom.